2 minutes to settle on-chain. 2 days to move the cash. That was Siemens in February 2023. 60 million euros issued on Polygon. The headline says blockchain fixed settlement. The plumbing says otherwise. Here's the teardown every issuer watching this needs to see. This is the most cited tokenization deal of the decade, and the only one that didn't overclaim what it delivered. Siemens built a real legal register on a public blockchain. They did not build T+0 settlement. Their honesty about that is why the deal is still cited 3 years later, and why it's the canonical reference for any issuer considering this path. Start with the legal wrapper. Siemens issued the bond as a crypto security under Germany's Electronic Securities Act, the eWpG, passed in 2021. That law lets an on-chain record be the primary register of ownership. Not a mirror, not a cache. The book of record. That matters more than it sounds. In almost every other tokenized bond, before this one and since, the legal register still sits off-chain with a paying agent, and the chain is a representation reconciled against it. Siemens inverted that. On-chain state is the register, the chain, Polygon proof of stake, a public network. Not a consortium chain, not a permissioned L2. Any observer can see every transfer. Transfer logic, strictly allow list. Only 3 institutional wallets could hold the paper: DekaBank, DZ Bank, and Union Investment. The contract rejected every non-approved address. Emergency controls, freeze, forced transfer, were encoded at the contract layer, not only in the legal documents. That was the asset leg. It wasn't the hard part. The cash leg was. And here's where Siemens was quietly honest in a way most tokenization announcements are not. They did not use a stablecoin. They did not wait for a central bank digital currency. They did not build atomic DVP. The cash settled through Clearstream D7, Deutsche Börse's traditional settlement rail. The same T+2 window every other euro-denominated bond moves on. So was this really T+0? No. It was on-chain asset issuance with off-chain cash settlement, and Siemens said so, openly. Their own release called it significantly faster than traditional paper-based issuance. True, without ever claiming atomic DVP. Every tokenization milestone since that has claimed T+0 is either describing a different structure, usually repo or intraday collateral, or quietly glossing over a cash leg still settling through SWIFT or correspondent bank rails. Asset leg and cash leg finalized on different timelines, through different systems. Every benefit you'd expect from atomic DVP, principal risk reduction, intraday collateral, real-time margin unlock, was not, in fact, realized. What Siemens proved wasn't faster settlement. What they proved was a workable legal wrapper and a clean on-chain registry model. To see why that matters, compare what came before and after. The European Investment Bank issued a 100 million euro tokenized bond on Ethereum in April 2021, 2 years before Siemens. It settled through a Banque de France CBDC trial, a clean experiment. When the trial ended, the rail ended. Société Générale issued a 10 million euro on-chain covered bond in September 2023, 7 months after Siemens. SocGen used its own euro-backed stablecoin, EURCV, for cash settlement. Technically, atomic DVP on the cash side, but the instrument was held almost entirely within the SocGen ecosystem. Limited external counterparty. KfW, Germany's state-owned development bank, issued a 100 million euro blockchain bond in July 2024 under the EU DLT pilot regime. Larger size, still T+2 cash. Every one of these deals chose a different trade-off on the cash leg. Siemens chose honesty and T+2. EIB chose a trial CBDC that didn't survive. SocGen chose its own stablecoin. KfW chose scale. None of them, as of this episode, has solved cash leg settlement at production scale with genuine external counterparties. That's why Siemens is the benchmark. Not because the rail was the fastest, because the honesty about the rail was the most operationally mature. Here's what Siemens explicitly did not do, and why each omission was strategic. They didn't invite retail. 3 institutional subscribers, full stop. A retail-inclusive tokenization would have triggered MiFID II prospectus obligations and consumer protection filings that would have dwarfed the transaction value. They didn't use a stablecoin. In February 2023, no euro-denominated stablecoin had the clearance for a DAX 30 issuer to settle payment through it. USDC or USDT on a euro-denominated bond would have introduced FX risk and regulatory ambiguity.
They didn't claim T+0.
Every other bank launching tokenization news in 2023 was over-indexing on the instant settlement story. Siemens declined the hype. Their marketing used significantly faster and nothing stronger. That restraint is what made the deal citable in regulatory filings afterward. They didn't make the bond freely transferable. Every secondary transfer stayed inside the contract-enforced allow list. No open secondary market. No reputational surprise about who ended up holding the paper. In a category full of theatrical launches, the restraint is the story. Reconciliation got simpler. It didn't disappear. The on-chain register has to match Siemens treasury books, Clearstream's cash statements, and trustee records. 3 books, same as every pre-blockchain bond. What changed is variance. Fewer mismatches, faster exception detection, machine-readable timestamps on every state change. Corporate actions, coupons, amortization, maturity, are automated at the contract level. Coupon calculation happens on-chain, on schedule. But the authority to release still requires off-chain treasury approval. Automation of calculation, not automation of authority. Important nuance. Audit trail, dramatically cleaner. Every state change timestamped, cryptographically signed, immutable. For institutional auditors, Siemens uses EY, that forensic trail is orders of magnitude stronger than paper. Legal finality, handled by the eWpG wrapper. A German court would treat the on-chain record as the register of ownership, not a legal fiction, not conditional on a central registry sync. That's new, and it's defensible. Honest scorecard, by dimension. Legal finality, on-chain, clean. A benchmark grade reference. Cash leg, off-chain T+2. Honest, not atomic DVP. Controls, encoded at the contract layer. Freeze, force transfer, allow list, all on-chain, all enforceable. Reconciliation, reduced, not eliminated. Corporate actions, calculation automated, authority manual, which is correct. Audit trail, the clearest operational win from the deal. Secondary liquidity, 0, by design. Cost of issuance, Siemens hasn't disclosed. Industry estimates put it at 300,000 to 500,000 euros, comparable to a traditional private placement the same size. So, a benchmark for legal and technical infrastructure, a non-event for settlement innovation, an honest reference. Any issuer looking at replicating what Siemens did has to make 3 decisions before they start picking tooling. Decision 1. Where does legal finality sit? On-chain, like Siemens under eWpG, off-chain, with the paying agent or custodian holding the register. Or hybrid. Siemens picked fully on-chain because eWpG permitted it and their council signed off. Not every jurisdiction offers that option. Before you issue, get a written legal opinion on record. Where the register sits is a binary that shapes every subsequent choice. Decision 2. What is your cash model? Bank rails, regulated stablecoin, tokenized deposit. Siemens chose bank rails. Right for them in 2023, probably right for most issuers through 2025. If your thesis requires atomic DVP, principal risk reduction, intraday collateral, 24/7 settlement, you need tokenized deposits, a regulated stablecoin, or wholesale CBDC participation. And your counterparties have to be on the same rail. If that alignment isn't there, don't claim T+0. The phrase T+0 claims are cosmetic entered the institutional vocabulary in 2024 for exactly this reason. Decision 3. What controls are non-negotiable? Transfer restrictions, emergency powers, audit observability, role boundaries. Encode the answers in policy documents and the smart contract, not one or the other. The deals that get cited in regulatory filings are the ones that made controls legible at both layers. 3 decisions. Take them seriously. The tooling decision writes itself after that. Siemens didn't prove T+0. They proved you can issue a real bond with a real legal wrapper on a public blockchain and not get anything operationally wrong. For most issuers watching this in 2026, that's the more replicable result. Atomic DVP remains a future state that requires infrastructure most issuers don't control. A clean on-chain register, legally enforceable, audit-ready, is something an issuer can build today.